All right, I'm Ryan Peabody. I'm here with my colleague Greg Treat. We're attorneys here in South Lake, Texas. Today we're going to be talking about LLCs, company formation. We get a lot of questions about this. We form hundreds of LLCs, and we get into a lot of different structures and variances of those, and we get a lot of questions about how they function, what they are. So we're gonna answer those, and then I'll give you a couple of stories for what we've seen. Good things and bad things when people get themselves into trouble or they're just creating a really good business and marching forward. And you know, the idea of business is to make money, and they make money. So we're going to get into that as well.
All right. So the first question that we often get is interestingly enough, do I really need an attorney to form an LLC for me? Can't I just have my CPA do that? How would you respond?
Well, first of all, what is an LLC? A limited liability company. This is a company, this is an entity that is formed by filing with the Secretary of State. We're here in Texas, so you file with the Secretary of State in Texas. And then you get an EIN, tax ID number for the company from the IRS. Those two things are the minimum. You file those, you now have a valid formed company, assuming you fill the paperwork out correctly. So who forms an LLC for you? I get this question more than any other question. Can I do it myself? Can my CPA do it for me? And obviously the big thing is when you're starting a company, you're trying to save money. I get that. I support that. But you want to do things correctly so they don't get you in trouble tomorrow, next week, next year, 5 years from now, whenever you kind of get up and going and you actually need to have a legitimately put together company. So can you form the company yourself? Absolutely yes. Anybody can really do legal work themselves. And what I mean by that is if you need a contract drafted, for example, and you want to put together your own contract, you can do that. Now, will you miss something, or will the quality of that contract be as good as going to a professional? I mean, let's be honest, probably not, unless you have experience in law or with that specific type of legal.
Right.
So yes, you can form an LLC yourself by doing those two things. EIN number from the IRS and a formation of the Secretary of State. But then it gets into what are the supporting documentation. So before I get to that, can you have a CPA form an LLC for you? So it's kind of tricky ground here. So the answer is, can a CPA form one? The answer is yes, because if they are going to form one for you, they are acting not as a CPA, not as a lawyer. They're acting more as like a scribe. Mm-hmm. They're taking your name.
Scrivener.
Yes, they're taking your name, they're taking your information, and they're entering it into a form and submitting that on your behalf. So can they form it? Yes. Will it save you money? Undoubtedly yes, because it doesn't take a long time and a lot of expertise to do that. But it's the same thing if you form it yourself, and here's the problem. So first of all, CPAs cannot give you legal advice. If they're giving you legal advice, it's not good. They're outside their lane. The CPA should be answering tax questions. Should we be taxed as an S-Corp election? Should we be taxed as a partnership? Great CPA questions. And that's who I would actually refer someone to get those type of tax questions answered. Whether or not they should be an LLC, an S-Corp, a C-Corp, a PLLC, which is a professional limited liability company in the state of Texas. Sometimes it's a professional corporation or a professional company, depending on what jurisdiction you're in, but you're a professional and you're licensed in that state. You can have that P in there denoting your professional status. But the big thing here is the operating agreement. So an LLC, it's called an operating agreement. You get into like a C-Corp or an S-Corp, they're bylaws, right? It's essentially the same document. It outlines how the business is conducted, how shares are given out, how we interact with the different equity holders we have in that business, how we sign contracts, how we do everything. It's your company Bible. It's your operating agreement. It's your operational document. And that's the document that you really need to have a good lawyer that practices in business law, that has formed these before. This is not their first outing. Form that document, because they're going to know what to ask, how to ask those questions, and they're going to give you the kind of advice that you need to form that document and to start putting that together. That's number one. Number two, and I'll kick it over to you, is you want your resolutions and minutes for your opening meeting that authorizes you to open bank accounts, authorizes you to name yourself as the president or the secretary or whatever it is of that company that is legally required by whatever the business code is in your state. In Texas, Texas Business Code, and it's outlined in there. You need to have certain minimum requirements and they need to be met. So what happens if you don't have an operating agreement? You don't have the minutes and resolutions done properly. You are ripe for the picking. So we do the formation, but we also act as a plaintiff's lawyer from time to time when someone breaches a contract for one of our clients. They have a company, and we do go after somebody or litigate against somebody. And the first thing I look for as representing a plaintiff in a lawsuit, in a civil action, is do they have their operating agreement? Do they have their minutes and resolutions? Are those legal documents in place? And when I see them having done it themselves, or they do it through like an online service and those documents are missing, I go, okay, great, here we go. We're probably going to win this argument. Because what we're talking about here is if you don't have certain things in place, and we'll get into more of this later with actual operations, is what I'm trying to do is pierce the corporate veil. I'm trying to take whatever entity that they have and disregard it. And I can do that through a variety of mechanisms. One of those is that they don't have the required legal formation, operational documents, minutes and resolutions, proper records. There's a good chance that I can get in there on behalf of my client and pierce the corporate veil, disregard that entity. And what I'm trying to do is I'm trying to get to their personal assets, because that's the point of an LLC. You want to have limited liability protection within that company. We'll get more into this in just a minute, but liability is limited in a lawsuit or anything else to the assets of that company. If we can get outside of that to their personal assets, that's when it opens up a whole new world. And the person that formed that, their purpose is defeated, and we are coming after their assets. So with our clients, that's what we're trying to protect them against. We're trying to limit them to their business assets, to their business operation. We see that they don't have these documents or don't have them done correctly. The person with that company, they have a problem. You might as well not even have an LLC if that's the case.
So I'm understanding you're saying that there's sort of two layers here. The first layer is getting the government documents, filling out those forms, which in theory you or a CPA could do, but if you do it wrong, you're exposed in a certain way. Is that correct?
Yeah, you're exposed, and you may not even know you're exposed.
So what would you, if you don't actually have an LLC, but you're conducting a business, what kind of business are you conducting, and what position does that leave you in?
So you're just a sole proprietor. You are acting as an individual. So when you're doing business and when you're doing a lot of things in life, you're wearing different hats. So I go to the grocery store, I buy groceries, or I go to the gas station, I buy gas, and I'm an individual. I'm me. This is who I am, and I'm transacting business from me as an individual with whatever, grocery store or gas station, whatever it is, whatever good or service that I'm obtaining. When I am conducting business, and let's say that I do something very simple, like go buy office supplies with a business credit card, I'm not buying that as an individual. I'm buying that as a representative or an agent of my company or the company that I am authorized to act on behalf of. So when I enter into, here's another even a bigger example. When I enter into a contract with somebody to provide them, let's say I'm going to provide them $10,000 of goods or services. Mm-hmm. I'm entering into that contract on behalf of my business, not behalf of me as an individual. So when and if that contract goes south and it ends up in a dispute or a lawsuit, I am now always representing my company and not me as an individual. So let's say that I have, I've got some money saved up. I got $50,000 in the bank, and I've saved that money up, and it's mine, and it's what I've earned, and I'm using that for my family and whatnot. We can get to that money if they are a sole proprietor and they don't have the business installation. In this case, we're talking about LLCs, the limited liability protection in front of them, and we want to avoid that. We don't want to do business unless we are doing it on behalf of an entity that we've created. That's how you properly do business in the world that we live in our society.
So the protected place that we want to keep our clients within is when they're an agent acting on behalf of the business.
Yes.
So that has two conditions, right? So the business has to exist, and it has to be clear that they are acting on behalf of the business, not on themselves. And that's why we need the internal documents, the company agreement, the bylaws, right, what have you, and those minutes and resolutions appointing them. So how do you indicate that you're acting on behalf of a business?
this is a very, very common mistake that I see very frequently. If you're entering into a contract, and you should always have contracts if you're dealing with anything more than just a couple $100, you really need a contract. Even if it's a simple one-pager, have the contract outlining your scope of work and how much money is involved for exchange of goods and services. You want to have listed on that contract not yourself. You want to have it listing the name of your company. So if I'm doing business with XYZ Corporation or XYZ person, and my company is, whatever the name of your company is, you have your company name listed as doing business with that person. And here's the big thing. On the signature line of that contract or on the signature line of anything, whenever you sign your name to anything, you always want to make sure it has the name of your company and you're signing on behalf of the company. So it'll look like this. It'll have the name of your company and then it'll have your title on there. And it can be member, managing member. It can be agent, president, vice president, whatever you want your role to be, or if you have a defined role, if you have partners, that's what you want it to be. If it doesn't say that, you write it in. You sign your name, comma, president, or comma, manager, or whatever that is, and that indicates on that legal document that you're not signing on behalf of yourself, you're signing on behalf of your company. And you always need to do that.
And if you didn't have a minutes and resolutions properly appointing you to that position, then signing in that way would create ambiguity, right? And that's what we're trying to avoid.
It would create a problem, yes. And little mistakes like that don't necessarily pierce the corporate veil and disregard your entity, but they add up in the category that would be against you if we were on a fact-finding discovery mission heading toward a lawsuit or heading toward a settlement or some kind of a negotiated exit of a bad deal.
Right.
So this goes back to dotting your I's and crossing your T's. You need to do this. And if you're not sure what to do, how to do it, a good business attorney will literally give you an instruction sheet, a step-by-step. We do this with all of our clients. Exactly how to sign your name, what that should look like, give you examples. And then if you don't have an example or you don't know, you should have the kind of counsel that can tell you. Or at the very minimum, please look it up so that you know how to do this and know how to conduct business properly.
So we've so far been talking about things kind of in sole proprietorship terms where this is a single business owner. What happens when you introduce partners?
Partners is just a slightly more complex version. So if you own the LLC by yourself, and it's a misnomer out there from years ago that you can't have 100% ownership in an LLC and still get liability protection. You can own 100% of the business as long as you conduct it like a business. You're in good shape. If you have partners, the operational document, the operating agreement, or the bylaws, if it's an S corp, are even more important, because they are going to give you information. So what if somebody dies? Who gets the right to buy them out? If they get divorced and a former spouse gets their shares in the company, you don't want to be partners with somebody's husband or wife that got divorced. You want to be able to have, probably not. You want to be able to have the option to buy them out. Those are the kind of things in your operating agreement. Let's say somebody goes bankrupt. Creditors come in. They want to buy the company. How do we deal with that? We want to be able to have the other partners buy them out. Or, hey, here's the big one. If there's a dispute, what is our mechanism from having somebody exit the company? What are their rights? What are your rights? And what we're doing here is if we map this out ahead of time, which is we're talking a couple $1,000s, right, to spend to map this out properly. In some cases, it's variable, of course, depending on the complexity of the business. But if you go to court or you go to litigation to sort these out, add some zeros to the end of that. You're now in the tens of thousands of dollars oftentimes to resolve problems that really shouldn't be problems to begin with.
Right. So how do you, we've talked about some of these involuntary transfers. Are there mechanisms for when somebody wants to just get out of the business? How do we deal with that?
Again, back to the operating agreement. A good lawyer will build in mechanisms in the operating agreement. They'll be in the back of the document somewhere for how to get out of an equity position, a partnership position in an entity. And that should be in there. Rights of withdrawal, rights of closing down the company. So all this to say, your operating agreement is very, very important. It should be part of your business plan to bring on professionals like lawyers, like CPAs, like, business consultants if you need them, if you're at that point, to help you form and operate properly your business. That should be part of the deal. Don't wing it. You're just going to get yourself into trouble. All right, 2 more things to be on the lookout if you have a Texas LLC in particular. One of those is your franchise tax filing. This is through the Texas Comptroller's Office. You get a state ID from the Comptroller's Office, and you need to file a tax return every single year with the Comptroller's Office in order for your LLC to remain in effect. It's about $1.2 million or above where you actually start getting taxed. So most small businesses, if they're making under that amount of money every year, they are filing a no tax due tax return. And they think, well, hey, it's a no tax due tax return. I don't have to file this. You've got to file it to make sure your LLC stays in active status, or the government of Texas will shut your LLC down for you. So that's something that you've really got to be careful of, and you got to do. It's not hard to do. If you need help, obviously go to your CPA or have your attorney give you a little guidance and put you in the right direction on that. But you should be able to go onto their website yourself, and it takes like 10 minutes. It's really easy. Make sure you do that, or you're going to lose status of your LLC.
And that's something that we always check, again, when we get in on this on the plaintiff's side. You go to the Texas entity, the Texas Comptroller's website, and check to see, is their entity live? Is it good?
Right. That's exactly correct. That's one of our first stops, because we're looking for chinks in the armor. We're looking for things that people didn't do correctly so we can get them. And it sounds bad, but keep in mind, if we represent you and you're the one we're advocating for, you may come to us, give us a high five and say, okay, guys, I'm going to win this lawsuit because they didn't pay me now. And we're going to win on something that we really shouldn't have won on, instead of winning something on the merits. Okay, so the last thing that I will share with everybody, as far as, and I get this question a lot, do I want an LLC or an S Corp? Most of the time, again, it's very custom. Building a business should be custom to you. It's a tailored suit. It's a tailored dress. If it's not custom, you're probably not thinking the right way. So should I have an LLC or an S Corp? Most of the time, we recommend an LLC because it's just a very flexible type of a structure. There's not restrictions on the amount of members you can have with an S Corp and a lot of the other restrictions involved in there. In my opinion, an S Corp is an antiquated business structure, business entity, because you can still have an LLC and still elect S Corp status for taxation purposes, so you're not missing out there on the tax benefit. So we strongly prefer LLCs that are flexible, and there's a lot of really, really good settled law that's come out of the Texas courts in the past many decades. So I feel very comfortable with them. We're not going to get into series LLCs today, but that's something we can talk about in the future. So as far as hot topics, things to look out for with LLCs, the formation, that's where we're at.
All right. Thank you so much for joining us, and we'll see you next time.